VCY America presents Crosstalk, a nationwide call-in program discussing issues that have an effect on our families, our communities, our churches, our nation, and our world. Crosstalk, an opportunity for you to voice your concerns for biblical principles. And now live by satellite and around the world on the internet at vcyamerica.org. Here is today's Crosstalk.
Well, thank you, Gordon, and welcome to Crosstalk. Vic Eliason, your host today, and we're looking forward to a great 53 minutes of vital information. Just first, quickly, a message to our friends in the North Country, up there in Cook, Minnesota, where we had a Sunday night sing, and the church was full. And what a great joy it was. The main sanctuary, I should say. There's an overflow area, but the main sanctuary was filled, and the music was just a thrill as people joined their voices in praise to God. Well, today we've got a very special guest who's a good friend and long-standing friend, Matt Staver, who's the founder and chairman of Liberty Counsel. And we're going to be talking about something that probably is going to ring the bell with most of you. We're going to be talking about Obamacare and the challenge. Matt, it's good to have you with us.
Thank you, Vic. It's good to be with you.
Now, Matt, yesterday the U.S. Supreme Court announced it will hear arguments involving patient protection and Affordable Care Act, commonly known as Obamacare. And we know a number of challenges that have been working through the courts. Which case or cases did the Supreme Court accept, and which ones are still pending?
Well, the case that the Supreme Court accepted was the case out of Florida with the 26 attorneys generals, or the 26 states that are on that particular case, along with the National Federation of Independent Businesses. They also were co-plaintiffs with the 26 states. That's the case that is going to be argued in 2012. Last week on Thursday, the Supreme Court conferenced together, and they looked at three cases that had been there. One was the Florida case. We all knew that they were going to take that case because that decision struck down Obamacare, and that's a review as a matter of right. It's not discretionary. When the Federal Court of Appeals strikes down a federal law as unconstitutional, the Supreme Court will get involved. If the court upholds the law, the Supreme Court has a discretionary review, and most of the time they don't review it. Only about 1% of all the cases requested for review are actually reviewed. So that case was there. We knew they were going to take that one. The question is, which one of the others would they possibly take? One case was our case, Liberty University versus Geithner, in which we represent Liberty University and two private individuals challenging the individual and the employer mandate. And the other case was the Thomas More Center case out of Michigan, and they challenged the individual mandate. Now, the court ultimately agreed to take the Florida case, in which they're going to review the individual mandate, the Medicaid component of the state's challenge, whether or not it's severable from the rest of the law, and then whether or not what is called the Anti-Injunction Act will actually prevent this resolution of the case before 2014. Now, that's a little complicated, but if I have a moment, I can explain it, and I think I know why the Supreme Court decided to put that into the Florida case as opposed to have our case separately argue it.
Okay.
The Anti-Injunction Act is an old law, goes back to the 1800s. It essentially says if you're challenging a tax, you have to first pay it before you file suit. You can't file suit before the tax is actually assessed.
To pay it under protest.
Yeah, pay it under protest. Then you don't like the refund, and therefore you file suit over the difference. And then you can also, if you want to, challenge the underlying law as unconstitutional. But you have to first pay the tax. Well, if that applied to this case, that means since the mandate doesn't go into effect until 2014, the penalty that is under the statute, even if you were to construe it as a tax, but the penalty as the statute calls it, would not be paid until sometime 2014 or 2015, meaning you couldn't file the case until after that time frame. That's what the court in our case ruled at the Court of Appeals, which put that issue squarely at issue before the High Court. So they have to review it. The Department of Justice, in their response to our case and to the Florida case, said that the issue of the Anti-Injunction Act has to be reviewed. They said you could actually require it to be briefed under the Florida case, which is going to be reviewed anyway, or you could separately grant the review of Liberty University versus Geithner and review it there. What the court decided to do is to put it under the Florida case. Now, that's actually good news. because the question of whether the Anti-Injunction Act prohibits the states from filing a pre-enforcement challenge is different than whether it prohibits individuals. Why? Because states are not taxpayers. So it's an easier question to overcome for states than it is for a taxpayer. Therefore, I believe what the court did was they, instead of having us separately argue that case, they put that onto the Florida case because I don't think they want to spend 5.5 hours of oral argument time, which is what they're doing, and then at the end of the day find out that they can't actually reach the merits of the mandate. So I think it's a safer bet to have the Florida state's case argue the Anti-Injunction Act because the states are not taxpayers like individual citizens are, and therefore I don't think the Anti-Injunction Act will prevent that case from going forward.
Let's talk about for all of us penguins here who don't understand all the ramifications of what Obamacare contains, but let's talk about what's at stake. If the Supreme Court upholds Obamacare, what are the ramifications?
Well, the ramifications are significant. Of course, Liberty Counsel will be still filing our brief, even though we won't argue the case, and I've already communicated with the attorney on the case, who I believe is one of the top skilled advocates in the country, former Solicitor General Paul Clement. He'll do a good job at arguing why this is unconstitutional. But if it is upheld as constitutional, here's the problem. It would mean that this unprecedented novel law, and there's a reason why it's unprecedented and novel, would ultimately become the rule of the day. If that's the case, that means that we no longer have a limited federal government. The Constitution sets up a federal government, but it limits its power to certain specific limited criteria, beyond which it can't go. Therefore, the remaining power is enjoyed by the states' rights, certain things that states do that the federal government cannot do. They can have police power. The federal government cannot do that with regards to the states. And then, obviously, the people retain the power. But if the federal government is able to force people to buy health insurance of its own choosing, its own design, when they choose not to buy health insurance, in other words, they're not entering into the market, they're not engaging in commerce, they're not purchasing an item, and therefore they can be regulated because of their purchase. They are refraining from entering into that market. But if government can now push you into the market, force you to buy certain products, this case, health insurance, then the government has literally superseded its authorities under the Constitution, and it ultimately overrides the individual states. It essentially takes over the states' decision-making. It essentially becomes the police power in the states. And so the states lose their rights, but more importantly, the people lose their rights. Because if today the government can tell us that we have to buy health insurance of a specific kind, not just health insurance, but of a specific kind that they arbitrarily design, then tomorrow, and this is not a stretch at all, they can literally require us to eat health foods because it's healthier and it would boost up local economy. They could require us to join a health club because it helps health and life expectancy and reduces medical cost. They could require you to buy not just a motor vehicle, but a certain kind of motor vehicle, a General Motors certain make and model motor vehicle, so that more people could have motor vehicles, you could have more motor vehicles made, therefore the cost could go down, we all need transportation. It goes on and on and on. Literally, they could force you to do anything. There is no longer a limited federal government. That is a significant difference in terms of the future of America. It cannot be understated how important this case is. And that's why instead of the typical 1 hour set aside for oral argument for both sides, 30 minutes and 30 minutes, the court set aside 5.5 times more time, 5.5 hours of oral argument time, which is unprecedented in our lifetime. No one listening to this message right now has lived during a time when the Supreme Court has had a 5.5 oral argument. This is unprecedented in modern history.
Well, Matt, what happens if the Supreme Court only strikes down portions, such as the individual mandate? Doesn't that make the whole thing come crumbling down?
What it does is it ultimately implodes the insurance market. 7 states have tried to enact 2 of the 3 things. There's the individual mandate, the coverage for pre-existing conditions and the community rating. Let me talk about those two last ones. 7 states tried to cover pre-existing conditions. Everybody who has a pre-existing condition, insurance companies have to cover you. And then they've also done away with community rating systems. What that is the insurance company's ability to look at risk factors based on age, certain kinds of medical conditions, and geography in order to exclude certain kinds of coverage to manage the risk. If the insurance companies no longer can manage their risk and have to cover everything that's pre-existing, well, you can imagine it puts an incredible amount of burden onto the insurance companies. 7 states tried 2 of those 3 prongs. 7 states failed. It ultimately resulted in the insurance companies leaving the state and the insurance system imploding, and so they all had to reverse and repeal those laws. An 8th state tried 2 of those, but it added a 3rd. That's Massachusetts, the so-called Obamacare. And they added the individual mandate. In order to put more burden on the insurance companies to require them to cover pre-existing conditions and eliminate their ability to balance their risk, the only way to make that work is you got to put more people into the coverage. You've got to cover more people, bring more people in, mandate them to be covered by this law. That's what Obamacare is. Obamacare is a supersized Romneycare. It was patterned after the state, and it's a supersized version of it. So if you take away the individual mandate and you allow the rest of the law to stand, you can see what will happen. On a national level, we'll experience what happened to the 7 states. The insurance system will implode. They'll go bankrupt. It will ultimately turn over upside down. And then guess what? 1 or 2 things has to happen. You either are forced to repeal it if you have enough votes, or a catastrophe happens. And guess what? It's like a General Motors. The government comes in, bails it out, and now you have a government-run, single-payer health care system.
Wow. Well, with the announcement yesterday by the court, the spotlight is now on Elena Kagan, Justice, who worked in the administration when the law was being written, and it's being said that she even helped to craft its legal defense. Should she recuse herself?
Well, certainly, if she doesn't recuse herself, there's nothing above her that says she has to. It's basically a self-choice by the justices. Now, the interesting thing is, yesterday, when the court decided to take some of the cases, she did not indicate that she was not part of the decision on taking these cases for Obamacare. But there's a couple of other cases where they either granted or they denied review that she chose not to be a part of. So she recused herself from those. So it does not look like at this early stage that she has decided to recuse herself. Now, there's arguments for Thomas, and we'll talk about that, which I think they're really ill-founded. But the arguments and the issues coming up for Kagan are more significant. And that is, was Elena Kagan, when she was Solicitor General of the United States, involved in working on strategy to defend Obamacare? And it looks like there are certain suggestions that she may well have been. There's no smoking gun with her signature on it.
We're going to take a break.
People right next to her were very closely involved in that strategy.
Matt, we're going to take a break and come right back in 60 seconds and pick up where we left off. Matt Staver, our guest today, and talking about, well, the Supreme Court dealing with this issue called patient protection and affordable care. It's known as Obamacare. We'll be right back after this minute.
Back to Genesis with Dr. John Morris, scientist and president of the Institute for Creation Research. Dr. Morris, let's talk about flying reptiles. What were they like?
Chris, well, obviously we have to speculate. We don't have any to study today. We just have their bony remains. A recent study of the skull of a pterosaur has shown that they had a well-developed organ which monitors head position and movement. The size of this organ indicates that they had a very good sense of balance, able to collect sensory input from the bones and joints and muscles all over the body to help it perform complicated movements while flying. You know, Chris, it doesn't surprise me that these animals were well designed. The creator of man is the creator of pterosaurs, and he did it all back in Genesis.
If you want to know more about the creation evolution issue, visit us on the web at www.icr.org. Back to Genesis is a production of the Institute for Creation Research. I'm Chris O'Brien. Thanks for tuning in.
And welcome back to Crosstalk, where today we're talking about the issue of Obamacare, and the Supreme Court of the United States of America accept the issue of Obamacare. We're talking about this issue, what's going to be happening with it. And Matt, we were in the midst of talking about Justice Elena Kagan. Let's pick up there where we left off.
Yes, of course, if Elena Kagan was directly involved in some of the litigation strategy and working to defend this case, then she should recuse herself. The bill was signed into law on March 23, 2010 by President Obama. And it looks like the acting Solicitor General, who actually argued the case against me at the Fourth Circuit Court of Appeals, clearly was involved in working on defense strategy. And it looked like from some notes that have been obtained through a Freedom of Information Act request that he was briefing or was closely working with or about ready to brief Elena Kagan. Now, again, there's no final smoking gun, but it looks like she was very closely involved, and certainly those closely associated with her. Even the person who was named acting Solicitor General when she was appointed to the Supreme Court were very much involved in the litigation defense strategy, knowing that as soon as it was signed into law, there was going to be litigation, and they were preparing the defense strategy already. So if that's the case, she should consider recusing. Now, the problem is that if she doesn't, for any of justice, there's no way to force them to recuse. So that's really a self-imposed situation when you get to the level of the U.S. Supreme Court.
I was getting up there. Well, the Democrats in Congress have been pushing for Justice Clarence Thomas to recuse himself because of some comment that his wife made about Obamacare. And as a result, they say he could not be impartial. What's your response?
Well, I think the case regarding Justice Thomas is completely different than Elena Kagan, because you can't be asked to recuse simply because your spouse is active or has made certain statements, even about a matter that eventually ends up before you. That itself does not show that the justice or judge would be biased, and therefore you wouldn't get a fair hearing. In fact, there was a case out in the West, which is a little bit different story. It's the Ninth Circuit Federal Court of Appeals judge, and his wife is an attorney and has been an attorney with the ACLU. And in that position, she actually filed a brief on appeal opposing Proposition 22, opposing the marriage laws out there. And that case then has ended up before the Ninth Circuit Court of Appeals with the judge. Now, in that case, when your spouse, when your wife in this case, is actually litigating on the actual case before you, that does have a conflict of interest, and in that case, he should recuse. But simply making statements where you're not directly involved in the case, but making statements that you're opposed to or support a particular law that eventually ends up before the court as a spouse does not in and of itself result in a recusal. You'd have to have more information as to why the justice would be biased and would not be able to give a fair hearing to the argument.
Now, Matt, the U.S. Supreme Court, in fact, I guess it was the White House, actually issued a statement that they are glad that the Supreme Court has accepted this case, and they're confident that the court will find it constitutional. Do you think that the Obama administration has real confidence, or do you think they're blowing soap bubbles?
Well, that's the Obama administration.
I had to add the humor there.
Yeah, I'd say that that's what they have to say. I mean, this is the signature piece of President Barack Obama. And, when he was running for President of the United States, he was opposing Hillary Clinton's mandate that she was proposing back in the 90s. And he says that you can't force everybody to be mandated to buy health insurance. Well, guess what? When he became President of the United States, that's exactly what he did. And this case will be decided right in the middle of the election cycle. It'll be decided by the Supreme Court no later than the end of June of 2012. So he's going to have a lot of egg on his face if this goes down. On the other hand, if it's upheld, he's in a catch-22 because it's going to energize a lot of people to go to the polls so that enough people will ultimately vote to repeal the law. Now, if that's the case, that's one thing. You could have enough people go to the polls and change the complexity of the Senate. You already have enough people in the House to repeal it. But if you got enough people in the Senate to repeal it, that's good. You could actually repeal the law. I think it has to go. The problem, however, is while Obamacare as a law would go, if it were upheld by the Supreme Court, the precedent would be there, thus allowing the federal government to come back with either Obamacare Plus or something else where they want to force people to buy certain things of their own choosing. So I think that at the end of the day, we really need to win this at the U.S. Supreme Court. It has to be won at the U.S. Supreme Court because it literally is two different visions for the future, and it's a complete departure from the Constitution and the limited authority of government if Obamacare is upheld.
Now, upon hearing the Supreme Court would take the case, the organization known famously for being the People for the American Way, unquote, issued a press release in which they said this. They said, for the past 30 years, the far right has systematically worked to reshape the federal courts, to twist the law, to support their policy preferences, and recently we've seen a disturbing shift in the Supreme Court itself. More and more, we've seen a distinct right-wing agenda placed or replace the common sense jurisprudence that has characterized the court's best decisions. There's no question that the authority to manage our increasingly out of control healthcare system for the benefit of the American public is well within the scope of Congress's powers. What remains to be seen is whether or not ultra-conservative wing of the court will let the Constitution prevail over political concerns. What do you say to that, Matt?
Well, People for the American Way, I mean, they have their right-wing watch. They follow everything that I do. They kind of are the paparazzi, I think, of conservatives. And, they report everything I say. They're listening to this program right now, and they report on it. They've lost credibility.
We've seen them even outline things we say on Crosstalk as though it was, something that they're worried about.
I know it's kind of really spooky that these people just kind of shadow you around. They really are the paparazzi of conservatives, and I have a page on Right Wing Watch where they basically follow everything I say and do. The fact is, People for the American Way has no credibility at all, and for them to say that clearly this is constitutional, clearly they don't have a clue. That's what I say to People for the American Way.
We've just got a couple more items. Then we're going to open the phone lines because I know a lot of people have some questions about where things are headed. And when you talk about health care, Obamacare, and all these things, there's a lot of people deeply concerned, some of us older people. We understand the 105 congressmen have signed a petition to overturn Obamacare. Will this impact the court at all?
Well, I think the fact is that the court knows there's a lot of public sentiment against this. I think it will actually, to some extent. You think, politics doesn't play into the courts. You'd like to think that, but sometimes, they're people too. They go home and they read the newspaper, watch the TV, and they live in their communities. And there is, I think, something to this particular political sentiment. First of all, if Congress has never exercised an authority in over 200 years, the precedent and the cases say, there's good reason to suspect that Congress even has the authority. Otherwise, they would have exercised that authority. Well, Congress has never exercised this kind of authority before. So exercising it now, you have to suspect that they've crossed their boundaries. Secondly, it's unprecedented when so many states jump on board. Almost 30-some states have filed suit or passed legislation opposing Obamacare. Unprecedented. There's only about 5 states that have come on record, 6 states at the most, to be in favor of it. You have to listen to that. And then finally, when the members of Congress are out there biting at the bits, wanting to repeal it, but for the Senate, they could repeal it, but for President Obama vetoing it, they certainly could. You have to listen to that as well. So I think all of that coming together really undercuts the fact that this is grounded in history, rooted in the Constitution, and part of the powers of the federal government. All of that goes to undermine that very argument.
Now, the Ohio voters, by a 2-1 margin, have approved a state constitutional amendment declaring Obamacare's requirements for Americans to purchase government-approved health insurance as being unconstitutional. Are Are you seeing a growing opposition from the states to this?
Oh, very much so. I mean, you have a state referendum that gets passed overwhelmingly in Ohio, which is not necessarily a Republican state. I mean, it's a swing state. It has gone both ways on presidential elections. And for this to happen, you obviously had to have a bipartisan group of people come to the polls, Republicans, Democrats, and Independents, in overwhelming numbers to oppose Obamacare. It's a direct slap against President Obama's Obamacare agenda. And you also have other state legislatures that have passed laws and legislation to try to limit or to stop Obamacare. And then, of course, just in this one case before the U.S. Supreme Court, when Paul Clement stands up, by virtue of that one case alone, he will be representing a majority of the states in the country just in this one case. Now, there's going to be more states that will file amicus briefs, but I can tell you there's only going to be about 5 or at the most 6 states, one of which will be Massachusetts, that will say, oh, this is great for the country. Well, you know, the vast majority of states, about 45 of them, are going to say, no, it's not. I think that carries a significant amount of weight.
Well, Matt, we're coming up here for the break, and I'm going to ask folks if you would, I'm going to open the lines right now, hit the button, and I believe, there we go. They're all loose and ready to go. All the lines are clear. If you'd like to call and talk with Matt about this issue, Obamacare, and I think the big thing, Matt, that all of our listeners always wait for, I mean, it's so easy we could all wring our hands in despair, but there is an answer, and the big question is, what can our listeners do? Well,
your listeners can do several things. Obviously, this is a critical case, and we need to have prayer for that. Mm-hmm. But also, Liberty Counsel, even though I won't be presenting the argument, we will be filing a brief. And we are collecting a lot of names. We have about 100,000 names already that will be presented that indicate here's a group of people that oppose Obamacare. So people can go to Liberty Counsel's website, lc.org. They can sign up to voice their opposition. They can call our toll-free number, which I can give later out in the program, mm-hmm. and they can actually sign up right there to voice their opposition. There's one place that they can go also, and it's called libertyanswers.com, libertyanswers.com. That will be up as we speak, and we will ultimately be able to have people sign there so that their voice can be registered against Obamacare. And we've got about 100,000 people that have done that already.
And you're on 95 radio stations today, and if we count up about 100 people from each one, you could add another 9,000. And if you add another 1,000, there could be a lot of response, folks.
Yeah, absolutely. And I think if you do that, I think, and of course, even after today, you can go back to that website and you can sign up. So that's what we need to do, and encourage people to sign up now.
Now that's lc.org. That's
lc.org, and then later on today, libertyanswers.com, libertyanswers.com.
And I think the 800 number is still the same one, 800-671-1776. We're going to be right back, and the phone lines are already starting to flash. This is Crosstalk on the VCY America Radio Network.
A growing controversy has emerged. Is Mormonism a cult? It's important you examine the evidence for yourself by reading the book The Godmakers. Ed Decker, who spent 20 years in the Mormon Church, has teamed up with Dave Hunt to write this shocking expose of what the Mormon Church really believes. Mormons claim to follow the same God and the same Jesus as Christians. They also state that their gospel comes from the Bible. But are they telling the truth? The Godmakers, one of the most powerful books to penetrate the veil of secrecy surrounding the rituals and doctrines of the Mormon Church, reveals the inner workings and beliefs of Mormonism. You'll discover the true nature of the Church of Jesus Christ of Latter-day Saints and its hidden worldwide agenda. Though penned in 1997, it gives proper understanding for the issues we're facing today. The Godmakers is available for a donation of $17 or more to VCY America by calling 1-800-729-9829. That's 1-800-729-9829.
And welcome back to Crosstalk. Matt Staver, our guest today online, and the phone lines are lighting up here. And maybe you have some questions about this issue of where Obamacare is going, or how it's going to affect you, or what happens, what the Supreme Court's going to do. And are you concerned, or are you just kind of shrugging your shoulders? Because as Matt mentioned moments ago, there are things you can do to raise your voice. And that's what America was designed for. Public input, public speaking out. There was if you remember, somebody said those famous words, give me liberty or give me death. Well, freedom and truth is a very important issue. And today, truth is kind of coming up short. We have all kinds of innuendos and false accusations and false facts floating around. But if there's ever anything that's going to affect our country, seriously, this healthcare thing, and it's kind of scary. We're going to go right now to Fairborn, Ohio. We're going to talk with Barbara. And Barbara, you're on the air with Matt Staver. Hello, Barbara.
Yes.
You're on the air.
Yeah, I would like to know if the Supreme Court overrules Obamacare, if it would affect the law in Massachusetts.
No, it would not, because that's an independent state law. What would ultimately happen is the question on Obamacare is whether the United States Constitution authorizes the federal government to force people to purchase health insurance. If the answer to that is no, which I believe clearly the answer is no, that does not answer the question in Massachusetts as to whether the state constitution allows the state to force its people to do the same thing on a state level. So it's not going to affect Massachusetts, but it certainly will stop Obamacare in its tracks.
Okay, thank you.
Okay, thank you very much, Barbara. Let's go to a gentleman on the road right now. And line one, hello, you're on the air. Go ahead.
Yeah, I having trouble hearing. Worst case scenario, if Obamacare is passed, two questions. One, would I be able to refuse it? They say, I understand I'd be forced to get insurance. Could I refuse that insurance on the basis of some religious belief, saying that I don't want to have drugs and that? And second question, could a different administration repeal it?
Yeah, good question. On the first question, you have to either have the kind of insurance that they want, not just any insurance, but a certain level of insurance that the government defines, or you pay a penalty. Now, if you ultimately have the insurance, that doesn't mean you have to use it. So you can have the insurance just like you have now, as an example, and you don't have to use your insurance. So, no, they won't force you to use it, but they would force you to either have it or pay a penalty if you don't have it. And the second question that you had there was on the issue of what was that again?
Could a new administration repeal it?
Well, they could repeal it? Yes, a new administration could repeal it. What you need would obviously be enough. You've got enough people on the House to repeal it right now. You need probably a little bit more on the Senate to repeal. You're going to need probably about a switch of 10 or so senators to repeal on the Senate. But then you also need a president who's not going to veto it. And so you really would need a switch in the presidents and also some changes in the Senate to repeal it. And yes, they could repeal it. The problem is that if the court upholds it, you could have a change, like I said earlier, and you could have somebody repeal it. But the court then would essentially sanction the concept that the government can force people to buy things. Now, Obamacare might be repealed, but the government would have that power now going forward on other things, which would be devastating.
Thank you, Ty, for your call. We appreciate it. We're going to move along because we've got a bunch more calls coming in. Our telephone number is 800-733-9829, 800-733-9829. Let's go to James in Rochester, Minnesota. And James, you're on the air with Matt Staver.
Yeah, good afternoon.
Good afternoon.
I went to a town hall debate a couple months ago in my hometown, and there was a third-party group, and they were housing about taking care of the United States deficit. On the sheet of paper that I had was a worksheet, and one of them was, should we appeal Obamacare? And it did not show anything how much savings it had if we remove Obamacare. It only showed what they think would happen with all the savings if we kept it.
Yeah.
There's a third-party group that's really been that's out in D.C., not like the Liberty Counsel or the Heritage Foundation, that really is not really telling everybody the truth about Obamacare.
Yeah, well, let me, when President Obama and the leading Democrats, Nancy Pelosi, Harry Reid, in the Senate and the House, ultimately were pushing this forward in 2009 and 2010, they ultimately said, we want to bring this cost in under $1 trillion. So lo and behold, CBO, the nonpartisan independent research arm of Washington, D.C., came out and said, well, the cost of it would be under what trillion? It would be about $900 billion. Well, the problem is that right after it was passed, the CBO said, well, our figures are wrong, and the cost is now exceeding $1 trillion. It's probably more like $1.2 trillion. Frankly, I think that the cost of Obamacare is probably closer to $2 trillion when you look at the impact that would happen on the individual states. It will literally bankrupt some of the states. It will explode the Medicaid rolls. The states, by some percentages, will go up 40 to 50% expansion of their Medicaid rolls. They're already chafing under the burden of Medicaid now. There's no way that they can expand 20 to 50% on their budget for Medicaid, and that's why the states are so concerned, because it will have a catastrophic impact on the individual states, especially during this current economy.
We're going to go to Kathy in Monroe, Wisconsin. Kathy, you're on the air with Matt Staver.
Hi. I think that we're already feeling the effects of this health care plan. I mean, our insurance premiums have gone up.
Yeah.
I mean, the company that my husband works for, they'll put in, so much, and then we pay half. But the deductibles are up to $3,000 out of pocket before they even pay anything, and you kind of wonder, what about the Medicaid and the people, if the IRS is going to handle this, with charging these fees. And my husband says, well, why would a company even want to, pay for anybody's insurance benefits? It's cheaper just to pay the fine.
Yeah, you're right. Well, there's a couple of things. What you're saying is true. First of all, I think the cost of health insurance is already being affected. Secondly, employers are not hiring because they are uncertain as to the impact of Obamacare, and they can't figure out what their cost is going to be. Thirdly, some employers, even some large employers, may ultimately take the route of paying the penalty. Because for some employers, it's going to be cheaper to pay the penalty than to cover insurance. What that means is people will be removed from their current health insurance rolls, be dumped off. Companies will take the less expensive route, and then all these people will be pushed into this exchange system. And that's ultimately going to increase the cost of health care and decrease the quality of health care at the same time and limit your choices. And I think at the end of the day, it's going to cause rationing as well.
Matt, could you take that exchange system and kind of break it out a little bit for our listeners who may not totally understand that?
Well, I don't think anybody, frankly, totally understands it, because it still is not clear as to exactly how it's going to work. Mm-hmm. What the problem with Obamacare is it's given the Secretary of Health and Human Services, which is Kathleen Sebelius, the former governor of Kansas, who is a very strong advocate of Planned Parenthood, and the late Dr. George Tiller, who performed late-term abortions. She is the one, or the person in her place, if she leaves that position, has a lot of discretion to shape what kind of health care the government wants and how these exchanges are going to work. But essentially, the exchanges are situations where they are insurance pools that will presumably be offered to individuals to choose from, that will ultimately be subsidized by some of these other penalties of people who are not actually paying, not actually obtaining insurance, but actually being penalized for not having the insurance. So that's essentially a part of what these insurance exchange systems are. They're designed to actually increase the coverage, but the fact of the matter is we really don't know exactly how they're going to work. And at the end of the day, I suspect they will increase cost. They will add bureaucracy, because when the federal government gets involved in something like this, red tape and paperwork and bureaucracy increase, and then the quality of health care will decrease.
We were looking there for a call coming in from Kalamazoo. We lost it momentarily. If you're still out there, let's get in on that. Right now, Ernest in Michigan. And Ernest, you're on the air with Matt Staver. Hello, Ernest?
Yes.
You're on the air.
Okay. I had a question. What if individually you cannot afford to buy into this insurance and you get penalties for not being able to participate in the insurance program? What happens then to an individual who can't?
Good question. Yeah, dependent upon your income level, you could possibly be exempt from it. But it depends upon what your income level is, and of course that can change. When this came in Massachusetts, the penalty for not having insurance was very small. But now the penalty has grown to several $1,000s a year. So there are some people that can't afford the insurance in Massachusetts, and they can't afford the penalty either. The problem is that the penalty can be pretty significant and add up over time. And, that's unclear as to what will ultimately happen with Obamacare.
Well,
I think at the end of the day,
when this program was first introduced, that those who couldn't eventually afford to pay into the program could possibly be jailed. What happens to a person
there's currently under the current version of Obamacare, and this also could be changed, by a legislature. They can't jail you, but they can assess the penalties and it goes onto your income tax just like a penalty would be assessed from the IRS. Currently, they can't jail you. But under IRS other assessment penalties, they could jail you. They could put significant penalties. They just haven't put that on right now. So all they have to do is just quickly amend that, and all of a sudden, boom, you're facing criminal charges and potentially jail. But right now, you don't have that. It's really unclear in terms of how some of this situation will ultimately play out. But we do know that for certain very low income, there will be an exemption. What will be available to those individuals, however, is not real clear because it hasn't been specifically spelled out by the Secretary of Health and Human Services.
Okay, well, thank you very much for that call last night. Now go to Navarre. No, this is Olney, Illinois. Olney online here, and Olney, you're on the air with Matt Staver.
Yes, this is a free country, and the president does not have the authority, and it's not his job to do what he's done. So it's already null and void. We should pay no attention to him. It's the people, for the people, by the people, and we are the ones, the states and the people out here. We can have insurance or not. It's not his place. He's overstepped his line, so it should be considered null and void right from the beginning. And I've known people in the past that's had 12 children, very, very poor. They could not afford any kind of insurance. They never, ever had any kind of insurance. And if their kids really got very sick, there was always a doctor somewhere in town or a small little office where you could go for $1 or $2 and just see a doctor if you really had to. And those places are still around. They've got them now.
I grew up without having insurance. My mother never had health insurance throughout the entire time I was growing up. And you're right, a lot of people oppose it. I think the president and certainly the Congress clearly crossed their authority lines by passing Obamacare.
Well, you're right, Matt. I grew up with no health insurance either as a kid. How do we survive? We'll be right back, folks, with the last segment of our program. By the way, that phone number, if you want information, 800, let's see, what is it?
800-671-1776, 800-671-1776.
For the Worldview Weekend Minute, I'm Brandon House. Our website is worldviewweekend.com. Recently on our radio program, I was talking with Dr. Jimmy DeYoung about the importance of starting with the Bible, and he agreed. He said, absolutely, Brandon, we don't start with the newspaper or the nightly news, we start with the Bible. Then as we read the newspaper, watch the nightly news, we can say, hey, wait a minute, doesn't that fit right with what the Scripture says is going to happen? You see, we have a sure word of prophecy. In fact, we are told that these things must happen for Scripture to be fulfilled. One of the things we're watching now is as Syria, Egypt, and Libya have all had rebellions in their nation, are throwing off their old leaders and going to even more radical leaders, perhaps even backed by Muslim Brotherhood. The Bible speaks of Syria, Egypt, and Libya coming against Israel. I believe we're watching end-time events unfold, not because I started with the newspaper, but because I started with the Bible. For more information on this topic, our website, worldviewweekend.com.
And welcome back to part number 4 of Crosstalk today. 8 minutes, we call it the speed round here. And if you have questions, the phone line, well, all of them are lit up right now. They're all jammed. But we'll take your calls as they come in, and we'll try to keep the questions quick and to the point, and so Matt will be able to answer that. And Matt, one more time before we go back to the calls, what people can do and where they can get information that will fill in the blanks for them.
Well, they can go to our website, lc.org. lc.org. They can call us toll-free, 1-800-671-1776, 800-671-1776. And then later today, they can go to libertyanswers.com, libertyanswers.com, and they can also sign the petition. We're wanting to get many signers and present this as we move forward. Liberty Counsel will be filing a brief in this case. Our case is at the Supreme Court right now. It's just being held. I won't present an argument, but I will ultimately file a brief. And we want to be able to get your signatures in support of repealing and opposing Obamacare. So libertyanswers.com is a website that will be very active later today.
And I'm not talking about needing a few, folks. When Matt says that, he needs thousands of contacts. And you can make a difference. Too many times we sit wringing our hands and woe be gone and here we are and whatever. But we can make a difference. We can stand up on our hind feet and let our voice be heard. And that's my encouragement to you. Rick in Navarre, Florida. And Nick, I have learned how to say it. Not Navarre, but Navarre. Is that okay, Rick?
Well, that's how the French pronounce it.
Okay. Well, I'm a Swede, so I mess it up.
I'm not French. I'll defer to how they pronounce it.
All right. You're on with Matt.
All right, thank you. I agree with both of you gentlemen that the act is patently unconstitutional, but so is Social Security, and after FDR threatened to pack the court in 1935, the Supreme Court has ceded to ruling that even that was constitutional. So the basic rule since then seems to be that if there's a political consensus among the leadership in Washington, the Supreme Court will rubber stamp it. And even though the Republicans in the House have been paying lip service to repealing Obamacare, the fact is they passed all the funding for it, and Boehner in the House, the Speaker of the House, even refused to go in and root out the $115 billion the Democrats squirreled away to implement it. And one final thought, my doctor tells me he's spending 3 hours a day inputting mine and other patients' records into the Obamacare system that will be used by the death panels. So this thing is being implemented, and $115 billion. I can remember when the whole federal budget wasn't $115 billion, and that's what they have to implement it. Okay, my question, since this thing is going to be, they're pouring concrete right now, even assuming we have a Republican Congress in early 2013 after the elections next year, and a Republican president, is it really possible to root this thing out?
Well, first of all, I'm praying that the Supreme Court strikes it down, because I think it is possible to root it out if you have enough people changed on the Senate side, and also, obviously, in the White House. You got to have somebody who's not going to veto this repeal. You already have enough people in the House who are willing to repeal it, but not in the Senate. And even if we get the ones in the Senate, you'd have to have 2/3 vote to override it, which we certainly don't have. A veto. So I think it is possible to repeal it, but if we repeal it but the Supreme Court upholds it, we get rid of Obamacare, but we have the problem of what Obamacare caused in its wake. A precedent at the Supreme Court that says the government has the power to force people to buy health insurance as long as they can pass it through the political process or anything else. And I think that is dangerous and certainly sets America on the wrong path.
We're going to go to Sheboygan, Wisconsin next. And, Mike, you're on the air with Matt Staver.
Hi. Something I've been wondering about, and I've never really heard how it would affect veterans with the VA. Would that be considered having insurance, or would you have to purchase the other care on top of it? And would that in some way be breaking faith with our nation's veterans?
Well, that's a great question. Right now, the veterans will not be, if you have that insurance, I don't believe that there's a provision that requires you to get Obamacare. But it may well be that the VA comes more in line with Obamacare. Otherwise, it really sets two different kinds of systems. And that may be, I think, where they'd ultimately go, is to really require veterans to have a different kind of insurance coverage, which would be very similar to Obamacare. And at the end of the day, I think Obamacare is not going to be good for individual patients. I think it's going to intrude on the doctor-patient relationship. And I think you'll clearly have rationing. And you had that with Ezekiel Emanuel, who was the advisor to the president on this issue, and he clearly believed that you ration health care away from people 0 to 14 and 41 and above. The group that gets the best health care is the 14 to 40-year-olds. Anybody on those two spectrums then gets rationed.
Well, when I think about the very early beginning of this particular administration, and I remember, I'm not sure the source of the comment, but it was a suggestion that veterans should get their own insurance because it was their gift to this nation to if they were injured in the service, and that they should get their own insurance. Talk about a heartless response. But that was floating out there.
Yeah, no question. I think, already for those that are veterans, you already see some problems within the VA-administered insurance process and the treatment, and that needs to be done in a better way. All of a sudden, you supersize this, and more bureaucracy than you can imagine with Obamacare, and you just complicate the problems that you already have in the healthcare system. We do need to reform the healthcare system. There's ways to do it, to be able to have people, more people covered and less cost. No question about that. But Obamacare is not the answer to it.
Matt, is 30 seconds left, and they're all yours.
Well, I would encourage people to pray and act, obviously. You can go to libertyanswers.com, libertyanswers.com. Later in the day, soon, that will be up, and you can sign your name to over 100,000 people that have already done so, expressing your opposition to Obamacare. You can also go to our website, lc.org, and call Liberty Counsel at 1-800-671-1776. That's 800-671-1776.
Man, it's always a privilege to have you, and I hope many people will be praying for Liberty Law School there and all the new students and young attorneys that we need, guys and gals that would honor God in their preparation. Thanks for being with us, Matt.
Thank you. My pleasure.
And thanks for joining us today on Crosstalk.
Listening to Crosstalk via satellite and the internet from VCY America. Views expressed may or may not be those of this station. For a CD of today's program, send a donation of $6 or more to VCY Tape Ministry, 3434 West Kilbourne Avenue, Milwaukee, Wisconsin, 53208, or download by RSS or podcast from crosstalkamerica.com. And join us again for Crosstalk.